Exceptions to vicarious liability. Introduction. Although the principle of vicarious liability generally makes one person liable for the acts of another, there are certain situations where this liability does not arise. These situations are known as exceptions to vicarious liability. Vicarious liability does not apply in certain situations called exceptions. An employer is not liable for acts done outside the course of employment or for personal purposes. No liability arises for torts of an independent contractor or for criminal acts unconnected with employment. The state is not liable for acts done in the exercise of sovereign functions. These exceptions prevent unfair liability and ensure justice in tort law. Exceptions to vicarious liability. Act done outside the course of employment. Independent contractor. Act done for personal purpose, frolic of his own. Criminal act not connected with employment. Acts done in exercise of sovereign functions. Unauthorized mode of doing an authorized act. Act done outside the course of employment. When an employee commits a wrongful act which is completely outside the scope of his employment, the employer is not liable. Case law, Beard v. London General Omnibus Co., 1900. Facts. A bus conductor, whose duty was to collect fares, drove the bus without authority and caused an accident injuring the plaintiff. Driving was not part of his assigned duty. The court held that the employer was not vicariously liable because the act was done outside the course of employment. Independent contractor. An employer is generally not liable for the torts committed by an independent contractor, as there is no control over the manner of work. Case law, Padbury v. Holiday and Greenwood Limited, 1912. Facts. An independent contractor hired by the defendant created a dangerous situation on the road, resulting in injury to the plaintiff. The employer was not held liable as the contractor was independent and not under the direct control of the employer. Act done for personal purpose. If an employee commits a wrongful act purely for personal reasons and not connected with employment, the employer is not liable. Case law, Joel v. Morrison, 1834. Facts. A servant, while going on a personal errand, caused injury to the plaintiff by negligent driving. The court held that the master was not liable as the servant was on a frolic of his own and not acting in the course of employment. Criminal act not connected with employment. An employer is not liable for criminal acts of the employee if such acts are not connected with the duties of employment. Case law, State Bank of India v. Shoma Devi, 1978. Facts. An employee of the bank fraudulently withdrew money from the plaintiff's account for his personal benefit without authority. The Supreme Court held that the bank was not liable as the employee acted for his own benefit and outside the scope of employment. Acts done in exercise of sovereign functions. The state is not vicariously liable for acts of its servants done in the exercise of sovereign functions. Case law, Kasturi Lal v. State of Uttar Pradesh, 1965. Facts. Gold seized by police during investigation was misappropriated by a constable due to negligence while in custody. The Supreme Court held that the state was not liable because the act was done during the exercise of sovereign functions. Unauthorized mode of doing an authorized act. If the employee uses an unauthorized method to perform an authorized act, the employer may not be liable if the act goes beyond employment scope. Case law, Beard v. London General Omnibus Co., 1900. Facts. The conductor drove the bus, an act not authorized by the employer, and caused an accident. The employer was not held liable as the act was not merely an improper mode but a completely unauthorized act. Conclusion. Exceptions to vicarious liability ensure that a person is not unfairly held responsible for acts over which he had no control. These exceptions balance the principle of liability with fairness and justice in tort law.